Good afternoon, everyone. We're going to go ahead and get started. I know there are going to be multiple people still coming in online. Welcome back to the Fairbanks Center for Medical Ethics lecture series. We are excited to start off again this season with another lecture on health law updates. And before we get into that, I want to preface by saying we thank you for your patience as we are transitioning to a new way to do attendance this year. So as you know, we're doing text attendance through CME. You received an email about how to complete a profile. If you have not done that yet, no worries. There's still time to do that. And you can do that by scanning a code. Let me get there. There we go. You can scan this code to create your CME profile if you have not already done so. This is hopefully going to be easy for us as we learn the process of this over the next couple months, and it will be a better way to and quicker way to get you your certificates that you need. Whether you need certificates through CME or through CE with IU Health, please do this. We're going to be using this for both methods of certificates. And again, if you are having issues with getting your profile completed, please just reach out to us. We will work with you as long as you are in person and have signed in, or if you are joining us virtually today, then we will be able to make sure you get a certificate, the certificate that you need. Please just give us a few days to respond to emails and a couple weeks to be able to get those certificates out to you. This webinar will be recorded today and will be available on our website in the next few days and will be available for continuing education for the next 30 days. And there will be information on our website about that, fairbankscenter.org. Now for the text attendance, if you are doing text attendance, you can now text 74086 to the number on the screen, and that should hopefully work for most people that have completed their profile. If it does not work, again, please just send us an email. I am going to put this number and code in the chat for those of you that are joining us virtually today, so you'll have plenty of time to get that completed. The Q&A box for those of you joining us via Zoom is open for questions throughout the presentation. We will not be answering most questions until the end when Dr. Hoss is ready to accept those questions. I will now turn it over to Professor Jane Hartsock to introduce our speaker today.
Good afternoon, everyone. I'm Jane Hartsock. I'm the Director of Clinical and Organizational Ethics for IU Health. Last summer, we introduced this new special education, special edition lecture to cover updates from the Supreme Court of the United States. And we're excited to bring that back to you again today. As you may be aware, there were multiple major decisions that are affecting certain healthcare practices. Professor Hoss is here today to walk us through those decisions and what they mean for us going forward. Professor Hoss has no financial conflicts of interest to disclose. Aila Hoss is an associate professor at Indiana University McKinney School of Law, where I graduated, and where she teaches and researches at the intersection of health law and federal Indian law. Professor Hoss practiced public health law as a staff attorney with the Centers for Disease Control and Prevention in their public health law program, where she provided legal technical assistance to state, tribal, local, and territorial governments. Her work at CDC included supporting the agency's Ebola Emergency Operations Center and serving as a faculty member for the agency's Working Effectively with Tribal Governments course. She was previously an assistant professor and faculty advisor at the University of Tulsa College of Law's Native American Law Center. Her scholarship has been published in notable legal and public health venues, including the Wisconsin Law Review, Nevada Law Journal, Public Health Reports, and Morbidity and Mortality Weekly Report. Her advocacy work includes lending her expertise and offering trainings to health departments, nonprofit organizations, and policymakers. Professor Hoss began her academic career at IU McKinney as a visiting professor for 3 years with the Hall Center for Law and Health. She completed her BA at Emory University and her JD at the University of Oregon. She is an active member of the Indiana Bar and a proud Iranian-American. It is my privilege to introduce Professor Hoss.
Thank you for the warm welcome, and I am so excited to be here. Jane preempted me because I was going to make a joke that I don't even know why I'm here. Nothing interesting has happened over the last few months, but you know that is not true, and we know that. So I actually have been feeling kind of anxious about this because so much has happened that I did not know how to pack it all in an hour, less than an hour if you include Q&A. But I did my best to highlight some of the high level themes that we're seeing in the Supreme Court and what they might mean, and frankly, why I'm very frustrated with them. And to kick us off, I'll just say, 'cause I'm a lawyer and I love disclaimers, that I'm not going to be giving legal advice, just providing an educational summary of some high level issues that I want us to think about. And then share that a quote from Professor Elizabeth Joe at UC Davis, who said that in the last week of the term, the Supreme Court unrecognized a constitutional right to abortion, expanded a constitutional right to carry laws. It's been called pretty regularly in the media the longest week, because those two decisions, among others, including an Indian law decision that's truly brought me to tears, have really shifted the game in terms of the lay of the land in a variety of areas of law, all impacting public health. Interesting, in our Dobbs concurring opinion, Chief Justice Roberts had said that overturning precedent is a serious jolt to the legal system. And we saw a lot of that, especially at the end of this term. The 6-person conservative majority on the court has made, according to Professor Joe, it clear that they are intent on changing constitutional law in a hurry and just getting started. I have already told my students this first week of class at the law school that I am getting to a point where I don't even know how to teach the law anymore, because the ground has shifted so much, and I am very concerned about where we're going from here. And emphasizing that we're not just thinking about substance of decisions, which folks might have their own views on, but in terms of how decisions are made and what we can expect in terms of relying on them. So I'm going to start us off doing a little bit of Law School 101, really more like, high school civics 101, get into our year for review, and then offer a few, again, doom and gloom concluding thoughts before Q&A. So, as you all know, there are a variety of sources of law that govern each of us as individuals, governments, corporate, nonprofit organizations, and law comes from a variety of places. In our federal system, we're starting with the US Constitution. It establishes 3 branches of government. Each branch of government creates their own laws or legally binding documents. The judicial branch has the important role of establishing common law case law. And so these opinions that are coming out of the Supreme Court and other courts are going to be, in theory, binding and creating precedent for future courts. So in the American family of governments, we have several governments, including the federal government, state governments, tribal governments, local governments, territorial governments. For the most part, I'm going to be focusing on the federal court system. That's going to be interpreting cases related to federal law, which is different from a state court system, which is going to be interpreting issues, cases, lawsuits related to state law. So the difference between federal constitution versus state constitution, state statutes, state regulations, as opposed to federal statutes, federal regulations. Universally, with some almost universally with some variations in name, court systems, including the federal court systems, have 3 tiers. The lowest tier with the most amount of courts at the lower level, where they actually hear evidence. The parties initiate the suit. Depending on the decision of the court, it could get appealed to the Court of Appeals. And then again, depending on the Court of Appeals decision, which isn't going to be collecting new evidence, but instead relying on the record created at the lowest court, making a decision, which again, it might get appealed to the highest jurisdiction's highest court. The Supreme Court has the option of taking those appeals. Supreme Court jurisdiction is outlined in the Constitution. Their original jurisdiction, so pretty much the only times that the Supreme Court could function as a trial court and collect evidence on their own, is when we have suits between states, cases involving ambassadors, and just a few other things that are a little specific and wonky. We think and learn and see the Supreme Court acting in its appellate function day to day. So that will be cases that are going to be implicating the US Constitution and cases involving federal law. The opinions that come out of federal appellate courts, Court of Appeals, the Supreme Court, become law in our common law system. Those facts that helped the court determine whether and how the law should be interpreted end up being a guidepost for future litigation. This is how, for example, the Supreme Court analyzed a treaty right and treaty language in a certain case between a treaty between a tribe and the United States. And so subsequent cases involving a treaty interpretation should be guided by what the court said before in terms of how that language should be interpreted. The idea is that we are going to be managing expectations, particularly when their facts are substantially similar to the prior case. I am sure you all know lawyers do a great job of trying to nitpick over what substantially similar means. So in actuality, this idea of stare decisis, the idea of following the outcomes of the judicial precedent that was made by the court before, has always had a lot of flexibility. Courts have always had room to narrow or expand. Courts have also always declined to follow precedent. For example, if circumstances have changed since the precedent has been established. Courts have overruled itself before. So courts have said in a variety of ways when they've deviated from precedent that maybe the factual basis is different enough to justify it, that circumstances, way of life has changed, society has changed. Sometimes courts will say the prior decision was ill-reasoned. Sometimes they'll say applying the previous decision has produced unanticipated and undesirable outcomes. This is another public policy argument. One of the most important examples in terms of stare decisis, following precedent and then deviating from precedent, is Brown v. Board of Education. 1896, the court had said segregation in public accommodations was constitutional. Brown v. Board explicitly overturned Plessy. I provide this example because it is one that for my students, for lawyers, for non-lawyers can point to and say, well, that makes sense. Good example of deviating from precedent, abandoning stare decisis. I want to read a kind of a long quote because I think this is going to be really important when we loop back to our conversations with Dobbs about just how seriously the court has taken stare decisis and deviating from precedent. Overruling precedent is never a small matter. Respecting stare decisis means sticking to some wrong decisions. Accordingly, an argument that we got something wrong, even a good argument to that effect, cannot by itself justify scraping settled precedent. or otherwise said it is not alone sufficient that we should decide a case differently now than we did then. This doctrine of stare decisis is really important. We even have in certain statutory interpretation cases a doctrine called super strong stare decisis. So it's even less likely, supposedly, that a court should be deviating from the law. It's something that lawyers and courts take seriously. This tweet I love, pre-Dobbs, my torts professor in law school taught me that an important component of judging is gaslighting. Many of the people we view as great judges today, like Cardozo, were great because they were good at persuasively arguing the line of precedents, which say X, actually say not X. That's also really common. So our courts, the judiciary jurisprudence has this attachment to stare decisis, putting it on a pedestal, but it's always, always been a gray area. Another piece that's really important before we dive into cases is understanding the Supreme Court docket. What is on their roll of cases that they're going to be looking at? There's a difference between the merit docket, cases that they're going to be looking at in the merits, examining the entire record from the lower courts, allowing briefings from the parties, allowing briefings from other parties that are going to be impacted to the decision, having oral arguments, issuing at the end a lengthy opinion explaining their decision. The point of the merit document, or the benefit of it, is it allows transparency. What has been dubbed the shadow docket, Justice Alito doesn't like that term, he would like it to be called the emergency docket, is different from looking at the merits of the case. It's about looking at decisions on procedural issues, very often the due dates for the briefs. But it could also include really important decisions. For example, if a lower court issued a preliminary injunction, so said, we are going to pause the implementation of this vaccine mandate until the litigation ends. Pausing that for the duration of the litigation, which very well could last years, is a really important step, or a really detrimental step, depending on where you are situated in that litigation. So the shadow docket puts these kinds of procedural issues in terms of whether or not to uphold the stay, the injunction, the pause or the not pause of a law is going to have profound impact. A shadow docket case does not have a guaranteed expectation for hearings or briefings and could be subject to very little explanation. Lack of transparency. It's been used on some major controversial issues before these days, but they have been occurring twice as often in the last few years and on some really controversial high-profile issues. Our current Supreme Court justices, 6 appointed or nominated by Republican presidents, 3 by Democratic presidents, and very routinely considered based on the literature and how they're talked about in the media, the conservative versus the liberal justices. Now, the cases that we're going to be talking about today are related to the term that theoretically hasn't ended yet, but Supreme Court takes a summer recess. And so we're getting through the cases in June when Justice Breyer was still on the bench. Since then, we have had a new justice get sworn in, Ketanji Brown Jackson. And but that doesn't necessarily change the dynamics in terms of the numbers for our conservative versus liberal justices. So let's tackle what this all means in terms of cases this year. And obviously, we have to start with abortion. We have had, until recently, under the Due Process Clause of the Constitution, 14th Amendment, a right to access abortion care. State governments shall not deprive the life, liberty, or property without due process of law. Due process, in general, often suggests this idea of something procedural. You have a right to a hearing, you have a right to notice, but it has been expanded to what's called substantive due process, this idea of life, liberty, property, as meaning some sort of right that's connected to the substance of how you might be living your life. So courts have found substantive due process in terms of rights to marry, right to raise your children. And in Roe v. Wade, 1973, the court had extended the substantive due process doctrine to the right to abortion under this idea of right to privacy. That we have under this clause, a fundamental right to privacy protects a person's right to an abortion. The court in Roe said that this right is not absolute, but the government has an interest in protecting health and protecting prenatal life. Roe adopted a trimester framework, a strict scrutiny standard, in evaluating when state law is going to be infringing on your constitutional right to an abortion. Because the court said this right is not absolute. It gave wiggle room for states to engage in a variety of regulation, including the one that was at issue in Planned Parenthood v. Casey, 1992, the Pennsylvania law requiring wait periods before getting abortion care and spousal notice, among other provisions. It reaffirmed Roe, central holding, didn't like the trimester framework, instead adopted a viability framework, abortion allowed until fetus can survive outside the uterus, abandoned strict scrutiny that a state law instead should not undue burden the constitutional right to abortion. And so we have had, since Roe and Casey, states implementing trap laws, shorthand for basically the different ways states have tried to limit the timing, the manner, the location of where abortions can take place. So then in Dobbs, we have Mississippi implementing a ban at 15 weeks. It expressly overturned Roe and Casey. They did not try to argue factually that we have to deviate, but instead outright overturned those cases. The court said, I bolded this, I made it red. There's another sign that's going to do the same thing, deeply rooted in this nation's history or tradition. This was a 6-3-ish decision along the lines of the conservative versus liberal justices. I say 6 because Chief Justice Roberts had a concurring opinion, agreeing with the outcome that there was a problem or not a problem with Mississippi's ban at 15 weeks. Roberts had an issue with the express overturning of Roe and Casey, which he said didn't need to happen under this viability framework, that 15 weeks was just too far along in a pregnancy. And that was enough grounds to be able to say, all right, no, this law can stand. This language, deeply rooted in this nation's history or tradition, what is it referring to? Rights that did not exist when the Due Process Clause was ratified in 1868. Take a step back from abortion and think about what rights, what life looked like in 1868. So I often get frustrated with the media. I call it their clickbait headlines about what they say about legal decisions, but actually I don't think they've been very clickbait lately. That maybe there is quite a bit at stake in terms if our standard is deeply rooted in the nation's history, depending on what was ratified in 1868, not to mention the fact, whose history? What's deeply rooted? Which communities are we going to be looking at? Another bold red, New York State Rifle and Pistol Association, v. Bruin. Look at these dates too. And look at these numbers in terms of decisions. 6-3, June 24th. This is the day before, June 23rd, another 6-3 decision. New York law required applicants for licenses to conceal carry, to show unrestricted concealed carry, to show proper cause or special need. The plaintiffs, along with the Rifle Association, including 2 individuals who were denied a permit to be able to unlimited, unrestricted concealed carry. One of these plaintiffs had a string of robberies in their neighborhood. And so their idea of special need proper cause in their application was, as a matter of self-defense, because of these robberies, I need to be able to have a concealed carry unrestricted. And the court, the state denied that permit. This law was a very long-standing law, had originally passed in 1911. The court said, Second Amendment, this state law couldn't stand. A firearm regulation must demonstrate that the regulation is consistent with the nation's historical tradition. Red bold again. Historical tradition. Another 6-3 decision. As in the case with abortion and Dobbs, we're waiting to see the very deep, expansive impact. What does abortion mean, or abortion rights mean, when you've got so many variations of state law? What do the prohibitions look like? Are they a civil prohibition? Are they a criminal prohibition? Are they criminalizing or putting liability on the provider? That's been what's most common. Or are they going to be moving towards criminalization and non-criminal civil liability to the patient? My colleague, Rachel Rubuchet, Dean at Temple Law, has long been working on studying and assessing the impact of state abortion bans, said just a few weeks ago, pre-Dobbs, but we had the draft opinion come out. She said, when the laws that try to regulate the behavior of providers fail in terms of limiting actual abortions taking place on the ground, states will move towards criminalizing patients. What are we going to see in terms of access to medication, abortion pills, even with FDA removing its or extending what had been originally a COVID-19 policy for allowing telemedicine? What are we going to see in terms of coverage for abortion care by insurance companies? What is this going to mean in terms of access to emergency services? What does New York State Rifle and Pistol Association going to mean in terms of the gun control laws in states like California or Hawaii? As if end of June didn't have enough going on. I didn't even mention that big Indian law case. It's outside the purview, but again, tears were shed. West Virginia v. EPA, June 30th, 2022. Another 6-3 decision. Whether the Clean Air Act gave the EPA authority to create emission caps based on this generation shifting approach. So moving electricity production from higher emitting to lower emitting sources. The court was very clear when it said that the Clean Air Act did not give the EPA authority, that it wasn't eliminating the EPA's authority to regulate emissions. One of the biggest public health crises of our time, climate change. There's so many reasons why this decision was both incredibly important in terms of its impact and a deviation from what we expect. For years, agency rulemaking authority, decision-making authority has been governed what's called the Chevron test, based on a case decades earlier, which said we're going to defer agency deference to their reasonable interpretations of what Congress says they're allowed to rule on. Agencies are part of the executive branch, but they exist because Congress created the agency, delegated certain legislative powers to them. So agencies can only conduct business that Congress gives them authority to do. Whether it's rulemaking authority, whether it's programmatic authority, whether it's permitting authority. Now, when I was at CDC pre-COVID times, we were very proud as an agency to continuously be voted the agency that had the most public trust, which is laughable now. Things have changed so much. But one of the reasons that was true was because the CDC has so little regulatory authority. Most of their work is technical assistance to state, local, tribal governments, territorial governments. Most of their money goes out of the agency in different funding mechanisms. So of course people weren't cranky with them. They aren't the FDA, they aren't the EPA with these broad swaths of regulatory authority. This case curtailed EPA's regulatory authority on an urgent public health and environmental health issue, but bizarrely was fixated on this generation shifting approach. The court said, oh, reducing emissions, regulating emissions is okay. We just don't like the way you decided to do it. Why would the judiciary be better situated than an agency to be able to make that decision? The court here relied on major questions doctrine, which is a made-up doctrine by the Supreme Court. I say this like jokingly, but actually the court has always made up doctrines. That's just the thing it does. This is a newly made doctrine, major questions doctrine. It's been a movement away from what I told you about Chevron deference, giving agency deference for their decision-making. And it's instead saying, if the agency is making a decision that has a major impact, it's more appropriate in the legislature. And so the agency should not be making these major decisions. Even if under the Chevron test, it would have been a permissible interpretation. I can't tell you as a matter of agency law, administrative law, how impactful this is, because we are saying ding dong, Chevron test is dead. The test that has been used for decades. The court doesn't even mention it. And in fact, it hasn't mentioned it in quite a few agency rulemaking policy decisions of late. So a way for the court to undermine which under the previous test would have been legally acceptable authority, rulemaking authority. So what does this mean? Every single climate change related regulation could get kicked out because of the major questions doctrine? y'all, look at, can y'all see this? My notes for the public health law cases. Couldn't put them all on the slide. I have to pick and choose what I'm going to share with you. These public health law COVID-related cases have been snatched up by the shadow docket with some caveats. National Federation of Independent Businesses v. Department of Labor. This was the OSHA, Occupational Safety and Health, vaccine mandate for all of the nation's workforce. They had exceptions. If you didn't want to be vaccinated for COVID-19, you would have to do a weekly test on your own dime, plus masking at work every day. Alongside, now we're looking at January 2022, same day we had this shadow docket decision. We had Biden v. Missouri. This was Department of Health and Human Services vaccine mandate. In order to continue receiving CMS funding, you must ensure your staff are vaccinated for COVID-19 unless you have a medical or religious exemption. Importantly, these were both shadow docket cases in that they were determining procedurally whether to honor the decision to enjoin, to stay, to pause, or not pause, a lower court's decision about whether those requirements should continue. What's interesting in these two cases, plus one more from late summer 2021, the CDC eviction moratorium case, another shadow docket case, is that we saw variability in terms of the amount and the level of decision-making. So altogether, NAFB v. Department of Labor had 30 pages with all the opinions. So whether it was dissenting, the majority concurring, and they did actually have an oral argument. Biden v. Missouri, altogether with all the opinions, 23 pages. Then our CDC eviction moratorium case, 16 pages altogether, no oral argument though. Some of these cases in the shadow docket going to the Supreme Court and decision coming out in a matter of a few days. OSHA vaccine directive blocked. CMS, HHS vaccine mandate not blocked. Because I'm a professor and I just want to cold call somebody. Does that make, anyone have an argument and why that makes sense? What about, even if you don't agree with it, what would you think? The whole nation's workforce versus CMS funded workforce. What's the difference? The facilities, right? We're talking about the difference between a healthcare facilities versus everything else. Restaurants, bars, accounting firms, law firms, factories. The court said, releasing these decisions on the same day, this is justified because there's a difference between a healthcare setting versus everybody else. That the participants in the programs that CMS regulates, Medicare, Medicaid, are going to be at higher risk. That the statutes that give CMS authority to do the programming, the rulemaking, the policymaking, specifically authorizes in their delegation of power that they have to ensure the health and safety of the participants. Sufficient congressional delegation, specific population base. I won't spend too much time talking about the facts of these two cases. Again, look at the dates here. June 21, June 27, So we're talking about Dobbs, West Virginia v. EPA, Castro Huerta. Carson v. Macon was regarding school vouchers, state school vouchers in Maine. In more rural areas where you might have fewer options for school, the state said, as a matter of the First Amendment, we can't allow public funding through the state school vouchers to fund private religious schools. And the argument is based on the First Amendment Establishment Clause, preventing the government from promoting or establishing a certain religion. Kennedy v. Bremerton School District, a football coach would engage in prayer with the student athletes on the field in school uniforms. The school said, Establishment Clause says we can't rubber stamp a certain religion, religious practices. So they said, you have to stop doing it. The coach stopped for a couple of days, went on social media. I'm not saying you shouldn't have, but intentionally, next game said, I'm going to go pray. And he did, and he got fired. Litigation. Both these cases, again, 6-3 decision, said under the free exercise clause under the First Amendment, preventing the government from prohibiting the free exercise of religion, you cannot have governments in both these cases use the Establishment Clause as a way to prevent the kind of activity here, whether it's prohibition of school vouchers in private schools or quiet prayer. Justice Gorsuch wrote the majority opinion in the Kennedy Bremerton School District case and talked repeatedly this idea of quiet individual prayer. The dissent did something that's not very usual, but it was part of the opinion of the lower court, which was include a picture of the quiet individual prayer. We've got lots of media attention because the coach had went on social media. Not quiet, not individual. Deviation from established law. Why this is important enough, in my view, to raise is because religious freedom, free exercise clause is very relevant to the work that we're doing at a public institution. You'll remember from last term, November 2022, free exercise clause was relevant in terms of removing restrictions to the gathering for religious events, religious services, because of COVID capacity restrictions. Free exercise clause. That too, again, last term, but I wanted to loop in our health connection. That was a shadow docket case. I should have shared earlier, but I didn't. One of the challenges of the shadow docket, the critiques beyond just this idea of transparency, is the fact that there is substantial confusion in terms of whether they are binding or not. Their impact, does it end up just putting a kibosh on the litigation because the Supreme Court had already just said we're not into this, so why should we pursue it? That's very expensive. What does it mean in terms of directives for the lower courts? Some lower courts have said, oh, shadow docket decisions should have less weight or no weight because it didn't go through the full decision-making process. That is undermining the appellate system that we rely on every day, whether it is to adjudicate individual contract claims, employment law issues, or governmental action. just because I know the slides will be able to be distributed, I included just a list of some of the other more healthcare related cases that I think you all will learn about in other settings. And I want to spend my last few minutes offering some concluding thoughts. We are having, and in some ways it's always been like this, seeing really inconsistent application of history, selective application of history in terms of what was the norm at the time of the drafting of the Constitution. Sometimes inaccurate history. Same with the science. Same with the science. We are seeing lack of trust in our government generally over the last few years, context of response to the COVID pandemic, among other issues, but have seen the greatest call for Supreme Court reform. We've undermined the validity of the institution. And many would say the continued fracturing of our democracy. There have been some movements for Supreme Court reform. They're getting more traction than ever. The Constitution establishes that the Supreme Court justices can't be removed so long as they're under like kind of good behavior. They could be impeached for bad behavior, but that in itself is going to be very variable in terms of what that means. It doesn't require life tenure. It doesn't require 9 justices. And that's why we're seeing more and more legislation that gets introduced, although none that have really made any movement in terms of let's put term limits. They can stay on the court, but they can be a senior judge, not necessarily going to be active in decision making. Let's change the number of justices. And then I go back to Brown v. Board. And approaching this problem, we cannot turn the clock back to 1868 when the amendment was adopted, or even to 1896 when Plessy was written. You must consider public education in the light of its full development and its present place in American life throughout the nation. Whatever may have been the extent of psychological knowledge at the time of Plessy, this finding is amply supported by modern authority. Any language in Plessy contrary to this finding is rejected. Plessy, let's talk about validity of science, was part of the argument was, oh, separate but equal doesn't have any emotional impacts on Black Americans. They're not being harmed in any way. Lots of evidence to suggest otherwise. Professor Elizabeth Joe. Incrementalism. Small changes to doctrine at a time when they feel like it. Sticking to prior decisions when they feel like it. Sticking to the text, the conservative judicial approach, originalism to the Constitution, sticking to the text, sticking to what was understood at the time the Constitution was written, but when they feel like it. States' rights when they feel like it. Individual rights when they feel like this. This is absolutely true, but it's always been true. I've always told my students this. We've never gone so far in terms of frequency of deviation, the breadth of the change in law. My contact information here if you want to continue any conversations, and I am delighted to open the floor for questions.
I do have one coming first right away online. So those of you watching virtually, please do feel free to put your questions in the Q&A box. Those of you in person, just raise your hand or flag us down, but we do need to have you use the mic so that they can hear you online as well. So the first one that came in is, it's so intriguing regarding the 6-3 decisions on many of those. Do they follow political affiliation or is it random?
Oh, totally. So I'm gonna do the annoying thing that my students don't like. and try to go back to quite a few slides. These decisions are following what we're seeing here. This was not always the case. This was not always the case. The number of 5-4 decisions when we had a 5-4 distribution has increased over the last few decades. You look at someone like Anthony Kennedy, who was a Reagan appointee, but was often viewed as a swing vote. Sandra Day O'Connor, again, another Republican appointee. Swing vote in a lot of cases. You look at, now we're going a little bit further, Justice Blackmun, another Reagan appointee, one of the most liberal justices the court's ever seen. So there's a lot of research on the role of political ideology on Supreme Court decision-making. Again, that research has always been there. Numbers sliced, diced. I think we've gotten to a point where it is just, it's so obvious that that's fact.
Okay. So I have a question as I'm looking at this about the role that the recitation of history is starting to play on the Supreme Court and in Supreme Court decisions. And so I'm specifically thinking about Clarence Thomas's concurrence in Box versus Planned Parenthood, where he went on this, he provided this history of abortion related to eugenics, which is an inaccurate recitation of history, because the primary method of eugenics was sterilization and not abortion. Anyway, so he provides that in his concurrence, and then that history gets re-recited into a footnote in Dobbs in the majority. And so it becomes in some ways kind of pseudo-substantiated history, even though it is demonstrably wrong. And I'm kind of curious about what your thoughts are on litigants affirmatively retaining historians as experts in cases to begin rebutting this kind of nonsense that's happening with these decisions, where people, because they're justices, get to just say, like, here's what happened, and you've got somebody who's got like a PhD, and you like, I'm thinking of Bill Schneider, who's our local, resident expert on eugenics, who can say, like, this is not actually what happened. And is there value in that, or how do we respond to that? Just because I feel like there's one thing, it's one thing when they're reciting law, they get to make law, they don't get to make history. And this bothers me.
Yeah, this is such a great point. And truth be told, I can approach this issue best in the context of Indigenous rights, tribal rights decisions. This, for different chapters of federal and Indian health policy, the idea was, let's make really good legal arguments based on precedent. And that is going to be the best avenue for a tribe to be able to get the legal outcome they want. And then we saw cases where the Supreme Court ruled against either tribal jurisdiction or a certain right, because they said, well, there was no evidence in the record to suggest that this was a historical or cultural practices that is inherent to the tribal sovereignty, right? Because the argument is tribes retain sovereignty, political sovereignty, to protect cultural sovereignty, that they need those legal tools to protect their children, their practices, their traditional and religious practices from infringement, protecting their environments and their lands from other jurisdictions. But the court said, oh, but you didn't plead culture. You didn't plead history. And then the lesson learned was then always plead culture and history. We are, when you look at judicial decision-making, we've got originalism, looking at the Constitution at the time it was written, versus, depending on what scholar you ask, you might have progressivism, living constitutionalism. There's not as necessarily agreed upon term, and this idea of the Constitution needs to adapt to the times. You see that also in the context of statutory interpretation. So textualism, we're going to look at the text of the statute. We're not going to care about public policy. We're not going to look at legislative history. We're not going to look at the news at the time versus intentionalism. We're not just going to look at the text because the text alone doesn't give context to why Congress wanted to make that law. Traditionally, originalism and textualism is what we see with the conservative justices. But we've got plenty of cases where conservative justices deviate from that and add public policy arguments. This is what Elizabeth Joe says, when it suits them. Again, this is not even just about the conservative justices. This is just justice in general, when it suits them. And so history, public policy arguments, disparate impact when it's convenient, regardless of the quality of the historical data, regardless of the quality of the studies that they're citing. I think it's a big issue. Tribes have done this for a long time, having to hire anthropologists, historians, and oftentimes non-native anthropologists, historians, to be able to demonstrate their cultural practices that they have been doing since time immemorial. It's a strange, perverse system. Thank you.
The next question, we have a few coming in online now as well. With health-related cases, or excuse me, not with what health-related cases or cases that could impact our work are slated for next term's docket?
Oh, so we've got quite a few, and I thought I had flagged some. We've got another environmental case in terms of controlling pollutants that I think it's going to be important. We have some of those kind of the ones I didn't really spend time in my table at the end in terms of the spending clause, in terms of what rights it might give to private individuals. That's pending. And we have another case that's set for oral argument in October, another environmental law case. So I think we've kind of got a lot that are teed up. And I'm there along with you all to see what's going to happen. Yeah. So we've got, if the Supreme Court is going to uphold the rule of law by application of various things without consistency, does this allow the resurgence of situational ethics? Interesting. I am not an ethicist. So Jane, help me out. Tell me about situational ethics. Okay, can you tell me what it means?
I cannot entirely define situational ethics. It is the idea that the rightness or wrongness of an action is almost entirely determined by the context and situation in which so it's sort of related to relativism, I guess, ethical relativism, except that that's a little bit more defined. So, I mean, I think what this person is asking is exactly the point that you're getting at, which is that there is so much unpredictability and the sort of absence of the analogical process that the court has generally followed, that what you're going to get is essentially case law that exists that can only be indexed to one particular scenario rather than being able to predict how it will apply to similar scenarios. And I think that's how I would interpret the question.
Yeah, and I honestly, again, in a lot of ways, I think this has always been the case. Just we've gone to a point that some of this we would observe across the Supreme Court and other courts, but now it's just the degree and frequency is so high. So yeah, I think this is what we've got. Another person asked, well, what do we do in terms of the balance of the court? I mean, I don't know. I think a lot of folks might not feel like the court is imbalanced if they were getting the substantive outcomes they want, right? There's a lot of impact in terms of making these big deviations to the court. And I personally do not have the right answer. One final question that I think I can squeeze in terms of impacting patient provider confidentiality, patient clinician confidentiality. The Biden administration, HHS has been really clear that they don't see shifts in terms of expectations in the context of protected health information. I think that is in practice going to be a lot more complicated. We already have instances where law enforcement can access certain health records or health systems. And and then, you could always be subpoenaed and compelled to provide information, right? You just need to have a judge. So I think it's going to be another one of those things that's going to be a little chaotic for quite a while. All right. Thank you all. Great questions. I appreciate your time.
Thank you so much. We will see everyone in 3 weeks on September 7th for our next lecture.